So I'd like to welcome all of you in this afternoon session. My name is Josephine Oyombe. I'm currently serving you as a council member at the LSK Nairobi branch office. And so we are having this webinar, and the series is Know Your Tribunal series. So as we welcome you for the session, of course, we have to also consider some rules of engagement so that we are mindful on what is expected of us. So the rules of engagement are only 3. The first one, let's ensure we mute our mics and we mute all our videos so that we can have minimal interruptions as we proceed with the webinar. The second rule is that if you'll have a question, because at some point we'll open the floor so that we can collect as many questions as we can. When we get to that stage, we request that you introduce yourself, give us your name, and then ask your question. And then the third rule would be that now that we've joined this particular webinar, it is expected that we make it as interactive as possible. So let's please ask as many questions as you have so that we can have a deeper understanding of the tribunal that we are considering today, which is the Land Acquisition Tribunal. So let's keep it interactive so that we all enjoy and we get to learn from each other. So without further ado, I will go to the introduction. So I'll introduce the guests that we have. We have 2 panelists. So our panelist number 1, who I have noted she'll join us in the course of the webinar. And if she's joined...
I'm here. Yeah.
Fantastic. Karibu sana, Honorable Anne. We are really glad to have you. So I'm glad that you're with us. And yes, I'll go straight into the introduction of our panelists. So the first panelist that we have, as you heard, is Honorable Anne Asuga. She is an advocate of the High Court of Kenya. She was admitted to the bar in the year 2002. She holds a bachelor's degree from the University of Nairobi, a postgraduate diploma from the Kenya School of Law, and she's currently pursuing her master's degree in business administration at the JKUAT University. So she has both academic and professional credentials in management, having attended several courses dealing with legislative drafting, performance management, managing legal resources in the semantic web, and project management. She's also a member of the LSK, the Institute of Certified Secretaries, the Kenya Institute of Management, and she has also published 2 books, and these deal with discriminatory laws, and the other book deals with case management in the judiciary with the help of Federation of Kenya Lawyers. So Honorable Anne Asuga is a registrar, and she's the head of the Tribunal Secretariat. So karibu sana, Honorable Anne. Then the second panelist, or maybe Dr. Honorable Anne, you can say 1 or 2 things before I introduce the second panelist. You can just say a quick hello, unmute your video and say hello.
Good afternoon, everyone, and sorry for the delay in joining. This technology sometimes can let us down, but I'm here now. I'm not able to unmute my video because of the space that I'm in. I'm in a school meeting that the rest of the people are not participating. So when we finish the meeting, I'll definitely show my face. But for now, the participants of the meeting are not part of this. I'm just finishing something. I rush out and then I'll concentrate fully on this, but I'm here now. Welcome to this program. And I thank the LSK Nairobi chapter for organizing this, and we'll learn more as we go along. Asanteni sana.
So thank you so much, Honorable Anne. The next panelist that we have is the chairperson of the Land Acquisition Tribunal. So if you will permit me to just give you a preview of his bio, Dr. Nabil Orina is an advocate of the High Court. He has over 14 years post-qualification experience. He's also admitted to the International Criminal Court list of counsel. He holds a PhD in law from the City University of Hong Kong, a Master's of Law degree from the University of Turin, Italy, and a Bachelor's of Law degree from Moi University. So he has previously worked with the defense teams at the ICC and the International Criminal Tribunal for Rwanda. He was also part of the Kenyan Judiciary Technical Committee, which developed a bench book for criminal procedure. So he has undertaken several consultancies in areas of national security, land law, environmental law, and many others. His recent consultancies include development guidelines for the investigation and prosecution of terrorism and terrorism financing for the Office of the ODPP. He has also trained the Intergovernmental Authority on Development, that is IGAD, delegates on transnational crimes. So Dr. Orina has published in the areas of international criminal law, human rights, and counter-terrorism. So karibu sana daktari. Maybe let me give you a chance to greet our audience and just say something. Karibu.
Thank you very much. Good afternoon, everyone, and thank you to the Nairobi branch for organizing this and for bringing us all together. I'm looking forward to an interactive forum where we can get deeper into the operations of the Land Acquisition Tribunal and get to know more about it, and get to ask questions and interact generally about its workings. Thank you very much.
Okay, so karibu sana, and thank you for that. So if anyone is joining us, the session that we are having is the Know Your Tribunal series. And for the day, we are just getting to learn about the tribunals. We've had this series for the longest time. That is, if any of you has been following up on our webinars and logging in. So this is a series that we've had, and we continue to engage with all of you as our members and stakeholders so that you can know what are the tribunals that we have and how can you go about filing or maybe getting redress depending on the relevant tribunal. So without further ado, the first question will be to Dr. Nabil. If you could kindly maybe introduce the tribunal that you chair, you tell us about its mandate so that we can get to understand it. Karibu.
Okay. So the Land Acquisition Tribunal is now established under the Land Act, which essentially came through an amendment of what was referred to as the Land Value Amendment Act of 2019, which then amended the Land Act to incorporate the Land Acquisition Tribunal. But previously, we used to have what was referred to as the Land Acquisition Compensation Tribunal, which was established under the Land Acquisition Act, which was subsequently repealed. And after the repeal of the Land Acquisition Act, then all disputes that were being handled by the Land Acquisition Compensation Tribunal were then handled by the Environment and Land Court. And I will come in a bit to the mandate of the tribunal. But the key mandate then of this previous tribunal was listening to grievances arising out of compulsory acquisition of land. Compulsory acquisition of land, of course, as we all know, is the exercise of that eminent domain by the government, by the state, which then brings about disputes in regard to the that arise from the right to own property, which is enshrined under section or Article 40 of the Constitution. So then, upon establishment of this tribunal in the year 2009, it wasn't immediately operationalized, and this is for the reason that the members were not appointed. But the membership then got appointed towards the end of last year. That was in September, which then has operationalized the tribunal. The tribunal has been in operation for now more than 6 months, and I will come to some of the matters that we have handled and the jurisprudence that we are developing around this area. But to start off with the question that Josephine has asked, essentially this tribunal, which is established under now the section 133 capital A of the Land Act 2012, is composed of 3 members, and that is a chairperson nominated by the Judicial Service Commission, another member nominated by the Cabinet Secretary for Lands, and a third member nominated by the Attorney General. So once they've been nominated, the 3 members are then appointed through a gazette notice by the Cabinet Secretary for Lands. That is the composition of the tribunal as it is currently. It's composed of 3 members. In its operations then, other than its composition, because as you can see, its composition, which is a very small composition of 3 members, the tribunal has the powers to co-opt any expertise. It may co-opt an expert to advise it on any matter before the tribunal. And just something briefly about the tribunal, and I'm sure our registrar will touch on this later when she joins us. Tribunals really are essentially supposed to be the technical, they're supposed to deal with very specialized and technical matters. So for us as the Land Acquisition Tribunal, the kind of matters that we get to deal with then are of a nature that sometimes you might require the services of experts like valuers, surveyors, etc., to advise the tribunal on a question that can come before the tribunal. I think then I could go. I will just briefly go through the whole bit about the mandate, the jurisdiction, how to approach the tribunal, and then we can come back to any questions or interactions or comments that we can deal with. So in terms of the jurisdiction of the tribunal, primarily, the tribunal acts as an appellate mechanism for decisions of the National Land Commission on matters that relate to compulsory acquisition of land. And in this regard then, because the Land Act has given the mandate of compulsory acquisition on the National Land Commission, so any decision of the National Land Commission in regard to compulsory acquisition of land then is appealable to the tribunal. So as we know, the procedure of compulsory acquisition of land, as enshrined in the Constitution as well as the law, is that if government desires, whether it's the national government or the county government, desires to acquire land for a public purpose, or in the public interest, then the government can do so. So the National Land Commission then does this on behalf of the government, the national government or the county government. So from the beginning, where an agency, let's say a department of national government or county government requests for acquisition of land that for a public purpose, from that time when that request is made and the National Land Commission makes a decision whether or not the acquisition is going to go ahead, the National Land Commission is required to follow a number of procedural steps until the end, which means that the compensation of just compensation for the person who's affected by this compulsory acquisition. So then when you look at relating this with to the jurisdiction of the tribunal, then you will find that there are a lot of legal issues that can arise. And the very first legal issue that can arise is whether or not this acquisition complied with Article 40, sub-Article 3 of the Constitution, and that is if the acquisition was for a public purpose or was in the public interest. So a party can challenge actually the first point of whether or not the acquisition should have happened. And when this happens, then that party can come to the tribunal to challenge the propriety of an acquisition on whether or not it meets the constitutional threshold. Be that as it may, even though a party is satisfied, or even though a challenge before the tribunal on whether or not an acquisition meets the constitutional threshold, a party can still challenge the amount of compensation awarded, or a party can challenge the acquisition itself, how the procedure has been followed, or whether or not the land acquired and the land left behind would serve any purpose. So sometimes you can see that a person who owned, let's say 2 acres of land, and the government says we're only interested in 1.5 acres of that land. So a party can come before the tribunal and say, look, the half an acre that remained from this acquisition is essentially rendered useless. So then it's upon the tribunal to determine whether this parcel of land that remained should have also been acquired together with the bigger chunk of land that was acquired. So primarily, the first jurisdiction that the tribunal exercises then is appellating. It's an appellate jurisdiction from the decision of the decisions of the National Land Commission, and that is under Section 133, capital C, subsection 1. There are also other related strains of jurisdiction, as stated under that article and under that Section 133, capital C of the Land Act. And if you look at subsection 6, it talks about any other matter relating to compulsory acquisition of land, creation of way leaves, easements, public right of way, shall in the first instance be referred to the tribunal. So the law says that despite the provisions of Section 127 and Section 128 of the Land Act and Section 148, subsection 5 of the Land Act, and if you go to those sections, you will find that Section 127 of the Land Act, for instance, says that any question as to interests, the validity of documents, shall be referred to the Environment and Land Court. So then you go back to 133C subsection 6, it says that despite this section, any question that touches on a matter relating to compulsory acquisition of land, creation of way leaves, easements, and public right of way shall in the first instance be referred to the tribunal. So it means then that the tribunal has jurisdiction in regard to determining interests on land, the shares, whether it's tenancies in common or joint tenancies, the shares when a compulsory acquisition has happened, all those determinations, or who should actually be compensated, and this goes into the rightful persons to be compensated, questions, disputes in regard to ownership. As long as there are matters that touch on compulsory acquisition of land, then the jurisdiction of the tribunal can be invoked. So when we look at this tribunal and we compare it with the previous tribunal that was established under the Land Acquisition Act, and then it means then you can see how its jurisdiction has been expanded to other matters that touch on even the creation of way leaves and easements. I know there is a Court of Appeal decision in Abida Nicholas, which was, I think, from the Court of Appeal in Kisumu, that talks about the question of way leaves and where the right jurisdiction should be. This is a question that has also come before us, and as I will touch on at the end of this presentation, on our jurisdiction, some of the jurisprudence that we've developed is that we have found that we have primary jurisdiction when it comes to the creation of bailiffs and questions on compensation. So despite the holding in the case of Abida Nicholas that the jurisdiction in regard to the creation of bailiffs is primarily with the EPRA, which is the Energy and Petroleum Regulation Authority, and which would then be appealed to the Energy Tribunal. That case was commenced before the tribunal was actually actualized or operationalized. So our reading of the Land Act is that Section 127 and Section 128, which Section 128 relates to any dispute arising out of a matter referred to under the Act, shall be taken to the ELC. But then when you read it together with Section 133C6, it says that if that dispute touches on any matter relating to compulsory acquisition of land, creation of bailiffs, easements, public right of way, then that dispute is properly before the Land Acquisition Tribunal at the first instance. And 148.5, it's in regard to compensation, disputes in regard to compensation when it comes to creation of a public right of way. So a public right of way, which then entails compensation of a party, if a party is dissatisfied, that party shall, in the first instance, come to the Land Acquisition Tribunal. The third way in which the third way of exercise of the jurisdiction of the Land Acquisition Tribunal is through a hearing of complaints which may arise out of Article 32, 23.2 and 47.3 of the Constitution in relation to compulsory acquisition. So when you look at Article 23.2 and Article 47.3 of the Constitution, these are articles of the Constitution which gives Parliament the powers to give, to legislate and give original jurisdiction to subordinate courts and also tribunals, jurisdiction to hear and determine application for redress of rights. That is in regard to Article 23.2. And in regard to Article 47.3, this is the power of Parliament to legislate, to give a jurisdiction to subordinate courts and tribunals to review administrative action. So in their wisdom, Parliament has given the Land Acquisition Tribunal powers to hear and determine questions in regard to violation of rights and questions in regard to administrative review of administrative action. So in exercise of its jurisdiction, the Land Acquisition Tribunal then can hear complaints that arise under these provisions of the Constitution. So when it comes to then the timelines, I think for approaching the tribunal, strictly under Article 133C, sub-article, under Section 133C, subsection 2 of the Land Act, appeals which arise out of the decision of the National Land Commission shall be filed before the tribunal within 30 days of the decision of the National Land Commission. So, and then once a matter has been filed before the tribunal shall determine the matter within 60 days. And this is one of the laws that actually restricts the timelines within which disputes can be heard. So for the Land Acquisition Tribunal, matters shall be heard and determined within 60 days. However, in regard to the two, which is in regard to the lodging of appeals within 30 days, and also in regard to the determining of matters within 60 days, the tribunal under Section 133C, subsection 4 of the Land Act, has power to expand timelines where sufficient reason has been shown, where has been shown by a party or by the tribunal itself, so motu, to expand timelines for either the determination or for the filing of any matter before the tribunal. It's important to note that this timeline for 30 days within which to lodge an appeal before the tribunal is only applicable to appeals. But when it comes to a complaint arising under Article 23.2 and Article 47(3) in relation to compulsory acquisition. For instance, it's a question of where a party is complaining that their rights to property under the Constitution have been violated because they have not been violated. They have not been compensated despite a compulsory acquisition happening. So that kind of complaint then would not be restricted within a 30 days period of lodging, because it's not an appeal, but it's a complaint which can arise 2-3 years down the line, where, for instance, a party received an award, but this award has not been paid. So it means that a party lodging a complaint, a constitutional on a right, on a violation of a right, a constitutionally protected right, then can lodge this complaint within any period after that violation has happened. So the powers of the tribunal then that the tribunal can vary. It can confirm the decision of the commission if it's an appeal. It can also quash the decision of the commission when it hears appeals arising from the commission. Moving on now to the procedure, so that then I give time to take a few questions and comments. The tribunal has powers to regulate its own procedure, and that, of course, has to be done with, through rules of procedure, which then have to be promulgated through the Chief Justice. The process is ongoing. We are yet to finalize on the rules themselves, because we have been in office for about 6 months. And as we are setting up, we are working on the rules, and we will involve all our stakeholders, which include the advocates, before the said rules are promulgated or published. So, but in the meantime, it does not mean that the tribunal is not operational. The tribunal is operational because, as we know, the rules are subsidiary, and they do not, the lack of rules does not restrict or does not prohibit the operations of the tribunal. So we have been allowing parties to come before us in the very simplified manner. Any party who wishes to approach us can do so in the most simplified manner, whether they are represented by an advocate or not. And as we go along, we have been issuing practice directions as once a matter is filed, to ensure that first, that we comply with the timelines that are provided, and two, that we at least notify the parties of what is expected of them when they come before us. So immediately a matter is filed. If a matter is filed today, we will, before the end of the day, issue directions on how the matter will be heard and disposed. These directions will entail timelines for filing of responses and appearance before the tribunal for the first mention, for purposes of taking further directions in regard to how the matter will be heard and determined. We have also developed a template, memorandum of appeal, because the main jurisdiction is really on appeal, which can be obtained from the Secretariat at any time. So it's a simplified memorandum of appeal, which sets out the party, the grounds of appeal, and and it has to be accompanied by the documents relied upon by the party appealing. For the complaints under Section 133C, subsection 8 of the Land Act, these complaints can be filed in any format, which, as long as that complaint has clearly identified the violation and the facts are stated clearly. Remember that any litigation that touches on, look at, for instance, Article 22 of the Constitution, and it should essentially follow the rules that have been promulgated, the Mutunga rules, I believe, that are still in use in terms of litigating violation of rights. So the parties are encouraged then to follow that format in order to ensure that they have clearly identified the violation complaint about the part of the Constitution or the laws that have been violated, as well as the facts supporting that claim. And in regard to appeals from the tribunal would lie ordinarily to the Environment and Land Court, and this is on matters of the law only. So if a party is dissatisfied with a decision of the Land Acquisition Tribunal, that party has a right to appeal to the Environment and Land Court for redress of that. So I think that is the rundown of the basics about the tribunal. That's the composition, its jurisdiction, as well as its procedure. But also, I thought I should also highlight on a number of matters that on a number of issues that have so far come to the tribunal. I can tell you that the tribunal has a caseload of 30 cases so far. And you can see that within the shortest period that we've been in existence, we've had such, a big uptick of cases to the tribunal. Out of those 30, I think, I don't have the exact record, but I think about 9 cases have been finalized and closed, completely finalized and closed. The files have been closed, and that is because we are quite strict in regard to our timelines. We ensure that the parties are adhere to the directions of the tribunal, and as much as possible, we try to avoid unnecessary adjournments or unnecessary expansion of time, unless there are matters within that are not within our control. Then we afford a bit of flexibility for parties to be able to file additional documents. For instance, I mean, some of the instances where we've had to invoke our powers to expand time have been where some crucial documents have been missing in filed matters. A survey report, evaluation report, and despite the best efforts of the parties, they're unable to obtain any of these documents. Then it becomes necessary, because of the technical nature and the specialized nature of this tribunal, like most of the tribunals, that we obtain, certain reports, certain evaluations, certain surveys to confirm whether the allegation, for instance, by a complainant that the acquisition took much more than what was gazetted. For instance, if a gazettement was for 5 hectares and the acquiring authority ended up taking 10 hectares, and there is no proper, ground survey report to show that, then sometimes we've had to make orders that we need a survey report to be availed before we can make a decision. So there are circumstances where, other circumstances where there's a dispute over ownership of land, questions that are arising whether the land that was acquired was private land or public land, and where a party is claiming that they have not been paid because the land acquired belonged to them, but the National Land Commission files a response and says that this land indeed was government land. They came to later realize that it was government land. It has then it behooves us that we take further steps to ensure that certain investigations are done. For instance, by joining the Register of Lands, joining the Ethics and Anti-Corruption Commission, so that they could also prepare a report and avail it before the tribunal to confirm whether or not the land acquired is public land or private land. So far, part of the decisions that we've made through rulings or judgments have touched on a number of areas that we as a tribunal are developing as jurisprudence. There have been questions of whether the commission, which is the National Land Commission, can review an award which has been issued, and in what circumstances that award can be issued, because these are cases that have come before us where parties have come to complain that the National Land Commission gives an award, and 2 years down the line, the National Land Commission takes back the award and issues another award, which is a revised award of a smaller amount. So these are questions that touch on, a fair administrative action, and on whether or not such powers can be exercised. So that is some of the jurisprudence that we have worked on. And if you go to Kenya law and type in the advanced search, you type the Land Acquisition Tribunal, you will be able to see a number of decisions that have been issued by the tribunal that touch on a number of these questions. And if you are, you have clients who have such similar questions that would need a resolution before the tribunal, then I think the first place that I would advise you to go to is look out for some of the decisions that we have issued that might guide you on the direction the tribunal has taken. Another issue that we have dealt with, a question that has come before us and we've dealt with it, is the requirements, the procedural requirements on the part of the National Land Commission in regard to the issuance of notices. That is the first notification of intention to acquire, as well as the notification of inquiry, where we have found that these notices are mandatory in nature and they must be served on the person. It's not enough to, for instance, just publish them in the Gazette notice. I know there is jurisprudence around the question of whether publication in the Gazette notice is sufficient notice, but the Land Act specifically requires that notices in regard to compulsory acquisition of land must be personally served on the parties affected. And there's good reason for this. If we look at the history of compulsory acquisition of land in Kenya, it was it had a lot of issues of arbitrariness, and so to ensure that there is a clean procedure and every party is involved along the way, then we have determined that such notices must be served. And if you read those decisions, then you will see how we've expounded on the importance of serving a notice, where we reiterate the findings of Patrick Musimba, the High Court in Patrick Musimba, where they stated that a party affected by a compulsory acquisition is a bystander or a substantial interest. We've said that even though that party is a bystander, they do not, the procedures in the Land Act are not merely, ticking boxes. They are meant to involve the person affected so that they can also be heard in terms of, this acquisition and how it affects their rights to property, their economic interests, economic endeavors, etc., and whether some adjustments can be made to ensure that at least the acquisition itself it does not impact them negatively so much. So, and then another area where we have developed a bit of jurisprudence is in regard to issuance of awards and whether a party is entitled to reasons for an award. And we have found that indeed a party affected by a project through compulsory acquisition of land is entitled to be informed of the reasons why that informed the National Land Commission reaching a particular determination in terms of the award, and that can be done through the supplying of the valuation that was relied on before the award was done. We've also dealt with cases that have come before us in regard to delay in making of payments once an award has been done, and we have found that there are certain circumstances where the rights to property have been violated as a result of the delays that have been occasioned by the making of payments. We've also had opportunity to clarify on our jurisdiction. So you will find about 2 decisions which touch on our jurisdiction in extenso, which then would be useful for you when you are making a decision of whether or not this is a question that touches on our jurisdiction or not. We've also dealt with the questions of the doctrine of lease pendants, where the National Land Commission sometimes argues that we're not making the payment because a dispute is in existence. So we've expounded on what exactly does it mean a dispute being pending before an award can be made. So far, in the 6 months that we have done this is how far we've come. The jurisdiction, the tribunal is national in nature. We receive matters from around the country. We are virtual. All the filings are done on the e-filing portal from any corner of this country. We hear matters virtually, but in certain circumstances, and we've done this in Malindi, and we also are doing this in Kisumu in the coming, I think, 2 weeks, where we have about 10 matters that are coming from Nyatike constituency in regard to land that was affected by compulsory acquisition. So in order to give effect to the to access to justice, there are certain circumstances where we make a decision that, and also if the parties do request that the parties involved would like to have the tribunal come in situ, then the tribunal can make such arrangements. But for convenience of most of the parties, the proceedings can be done online, and we have been doing this for the many cases that we've had so far. So that is a very long brief. I don't know whether it's brief or long, about the tribunal and the legal around it and how far we are so far. I'm looking forward to questions, comments, so that then we can enhance this discussion. Thank you.
Yes, thank you so much, Dr. Orina, for that elaborate background when it comes to the Land Acquisition Tribunal. I'm sure we've gotten to learn about the mandate that has been clarified in broad terms. We've gotten to have a feel in terms of the current matters that you are addressing at the Land Acquisition Tribunal. And I just have to commend the fact that out of the 30 cases you've had so far, you've concluded a significant number of the matters. So indeed, that Land Acquisition Tribunal is definitely doing a good job. So thank you so much for that elaborate background, and we will come back to you with the questions. So for colleagues, as you have heard, if you have any questions, you can start posting them on the chat, and we'll also give you an opportunity to raise up your hands, and if you need to speak, we'll give you the chance. And then also, I understand there was a problem with the link that was shared. So if there's any of our colleague who maybe hasn't had a chance to join because of the wrong link, those of us who are here, we can share the correct link so that they can also get to benefit from this. So we'll proceed to our second panelist, who is Honorable Anne Asuga. Honorable Anne, you've heard what Dr. Nabil has said in terms of giving us that elaborate background on the Land Acquisition Tribunal. So what I'd like to know is, in your capacity as the registrar and the head of tribunals, how have you interacted with these land acquisition tribunals? And then, I don't know, how does your office relate to this particular tribunal? Maybe you can also just give us that background and let us know of your mandate. Karibu sana.
Good afternoon, and thank you, everyone. Thank you, Dr. Nabil, for that elaborate exposition of LAT, Land Acquisition Tribunal, and thank you, Josephine, for moderating this session. Welcome, everyone. As you've heard, my name is Anna Suga. I am registrar in charge of the tribunals in Kenya. And just by a way of brief background to give a historical perspective of how the tribunals have come into the judiciary, we might be all aware that pre-2010, all the tribunals were domiciled in the executive, and post-2010, Article 159 accurately captured the transition of tribunals by declaring or decreeing at Article 159.1 that judicial authority is vested and shall be exercised by courts and tribunals. And that is our operational article. And so tribunals, being clothed with judicial power, are run by panels and expertise in different sectors of the society. And so in 2014, the Minister for Finance, or the PS for Finance, transferred to the judiciary money and tribunals to be run under the judiciary. And in 2014, they transferred about 10. Then 2017 transferred at about another 10. And currently, the judiciary is administering about 25 tribunals in total. And in Kenya, we have done our survey and a very deep background of the tribunals that exist. We have about 39 tribunals, including the very, very recent one that has been established under the Social Health Insurance Fund. There's going to be a tribunal under that law. And so the tribunals are increasingly becoming doorways of access to justice in the country. So out of the 38 that exist currently and are established, 25 of them are administered under the judiciary, and we oversee their coordination. And to answer your question on how we relate to the Land Acquisition Tribunal, or indeed to all other tribunals, we are the support services office under the judiciary, and we are the link between tribunals and the judiciary. As most of you may know, tribunals are part-time. They do not sit on a full-time basis because the people who sit in tribunals are experts in their fields, and the caseload that we have in the different tribunals does not warrant full-time sittings. The judiciary has only one tribunal that is full-time, meaning they sit or ought to sit on a daily basis, the Tax Appeals Tribunal that transited in 2022. The rest are part-time, but mostly you will find even the part-time is almost full-time for some, like the Business Premises and Rent Tribunal and the Rent Restriction. So we have those variations, but invariably all the tribunals are part-time, and so members earn allowances as opposed to salaries, and they only earn that when they actually sit on a matter. And so our office, the Tribunal Secretariat, we offer corporate, financial, human resource, ICT, supply chain management, and other services on a corporate basis, because the tribunals as established have not yet reached the status of having standalone secretariats. And so for economies of scale, we buy machines or equipment or furniture or infrastructure in bulk, and we operate under a concept called shared services. We are located, majority of the tribunals are at Kenya Towers, which is in Upper Hill next to ODPP office, and that's where including the LAT that Dr. Nabil chairs is located as well. So we provide shared courtrooms because people are not sitting every day. We provide shared chambers when the chambers are equipped with the necessary infrastructure, internet connection, the coat of arms, the flag, and everything needed by a judicial officer, including machines, to just hear matters, articulate or have case conferencing with the members. And we also utilize shared boardrooms under the shared services concept. That ensures we have optimal utilization of resources, because the resources are scarce and unavailable. And so we need to optimize allocation. So we have, we support LAT and all other tribunals with human resource, court administrators, court assistants, financial support, whatever other support is required to ensure that the tribunal functions optimally. And I must say that LAT has really kicked off, because they are, I think, the latest to come in, or the second latest, which was, I think, June last year, and they hit the ground running. And so the gravitas with which the chair and the members have picked up their work is quite commendable. So basically, the Office of Registrar Tribunals is a support service and standardization of service office to ensure that quality standards are maintained across board. Members are paid on time. Infrastructure is provided in the best way possible, but also to try and seek out how to devolve services from Nairobi, because majority of the tribunals are only in Nairobi. And so we need to get into the counties through whatever means, including just establishing of shared services in the areas where high court stations exist. For instance, if you look at Mombasa, we have a shared services center for all tribunals at the Mombasa law courts. We have another one in Kisumu Law Courts, where lawyers can actually get services of any tribunal, not necessarily the ones that are in the regions, because we are on e-filing. All tribunals are on e-filing, and all tribunals carry out virtual sittings. But we have tribunals, because of the clientele and sometimes the nature of matters, depending on how the tribunal feels the matter is, that we have physical hearings that are necessitated in certain instances. So there are certain instances where a chair would feel that a matter may not be, justice may not be served if it's done virtually. And so we have to support either a circuit sitting or support a physical sitting, and our office exists to do that. So we are a supportive services office, but on a corporate basis. So the shared concept is what we find to you, including human resources, because if Dr. Orina, as the chair of LAT, sits 3 times a week or once a week, he may not necessarily require a whole contingent of teams that are full-time, to only sit perhaps or support once a week. So the same team that is supporting him is supporting another tribunal that sits on a different week, to ensure that you optimize resources in the judiciary, because we have very limited resources. So that is basically the role of the Office of the Registrar Tribunals. And I've said we are currently supporting about 25 tribunals currently. We have about the big 4, we call them the big 4. The entire tribunals that we support have a total caseload of about 22,000 as we speak. The cooperative tribunal is a standalone cooperative. It's a standalone tribunal because of the caseload. They are situated at Reinsurance Plaza in town, and they share their space with the HIV and AIDS tribunal on the concept of shared services as well. We have the business premises rent tribunal is also at Kenya Re Towers at Upper Hill, but also has a different secretariat that is not necessarily shared because of their caseload. They have over 5,000 cases. The tax appeals tribunal, it's a full-time tribunal with its own full secretariat because its caseload is also high. They have about, I think, 1,400 cases. And the rent restriction tribunal is also on the same wavelength. They're also not, they don't have a shared service because their caseload goes into the 9 of thousands. So those are the big 4, but others are coming up that have caseload increasingly every day. The HIV tribunal, surprisingly, is getting increased caseload from 80 cases onwards, which, based on the nature of matters coming in, which is discrimination on the basis of suffering from HIV and AIDS, or people living with HIV and AIDS, then it's worrying that we have a trend of litigation in that area. Another area that is picking up is the sports disputes tribunal, which has an upward case of over 40, 50, and also many cases over about 30 plus that deal with doping from athletes, and the sports tribunal is also dealing with that. So we remain committed to ensuring that we decentralize or devolve these services. Even though the members are headquartered in Nairobi, there is increasing need to raise visibility, raise awareness, and we have done several sensitizations in conjunction with LSK. In the last week, we were in Eldoret and we were also in Nakuru, and there was very great reception about tribunal. So we hope that this can be a continued collaboration to ensure that this information is shared with all Kenyans, all people in the Republic, so that they can access tribunals. And so I welcome lawyers to utilize the forum, because our turnaround time, or the turnaround time for tribunals, is quite short. A majority of the tribunals render their decisions within a period of 70, 80 days, which is sort of like 2 months, 3 months, the decision is done. But we also have very serious challenges, especially with regard to execution, because majority of tribunals, except perhaps 2 of them, cooperative and I think BPRT, they have power of their own execution. I suspect BPRT mostly not. So majority of the tribunals don't have power to execute their own decisions. And so a decree has to be, deposited or gone, taken to the magistrate court or taken to the high court to be executed there, which delays the process because the three major pillars or the substratum of why tribunals are formed or established. One is speed because they are expected to be expeditious. The other one is expertise, and the other one is affordability. And expertise, by expertise, I mean the specialization in different fields from the different government sectors or technical sectors. And so when you have execution happening in another forum, it's an extension of the time, which then the fruits of the judgment are not realized as quickly as they should. And so the tribunals bill, which is pending in Parliament, seeks to address this conundrum in terms of time, and we hope that Parliament will soon, pass that legislation to cure some of those challenges. And so we continue to ensure that we refine our systems, leverage on ICT, and make sure that we are able to increase our efficiency and meet the targets that we have set for ourselves, so that we do not create more backlog than we already have. So thank you very much. I'll be ready to take any clarifications or questions. Asanteni sana.
Okay, thank you so much for that presentation. In terms of the tribunals and how you interrelate with the different tribunals, we've learned a lot. That we have a number 39 current tribunals. And before we open up the Q&A, when you office and HIV and AIDS and tax appeals, or what did you mean by the big four? And then also, if you could just on the for the public who might in the other regions outside Nairobi. And as you respond to that, I am aware that, of course, ICT is of big help because, again, I'm sure you leverage on that. But then what about those areas, uko mashinani, where even accessing ICT is a problem? So how do you reach out to them to ensure that they also get your services?
Thank you, Josephine. I lost you at some point. I have just heard about mashinani and internet. The rest of the questions, I think there was interruption and I didn't get the entire question. I just got the part of mashinani and if leveraging. I didn't hear the rest of the question.
Okay, let me repeat. Am I audible?
I don't know whether it's my internet or yours, but there's break.
I think it's Josephine, Josephine's internet because I
Confirm
can
you
hear
can
you,
hear
but she's
me?
breaking a bit.
Try and check on what could be the problem on my end. But then indeed, the question is on the members, or rather the public who are based outside Nairobi. The fact that you said most of the services are in Nairobi, so how do you reach to the Mashinanis who can't even access internet and they are in need of services? So Honorable Alago, Honorable Asuga, please, if you've heard.
Yes, so the only question I've gotten is the one of the people in the outskirts who need who need to reach tribunals but cannot because of technology, or they're in Mashinani. And you know, the judiciary is currently implementing the social transformation through access to justice. And one of the pillars of that vision, or that blueprint, is reducing the distance or proximity to courts and tribunals, as it were. And so even if we have technology and majority of the tribunals sit in Nairobi, there's a lot of collaboration, and you remember there has been discussions between the judiciary on the use of Huduma centers, because approaching courts and tribunals is the same challenges are experienced whether in courts or in tribunals, in the sense that if we leverage technology and the people who are at far-flung areas do not have access, then we need to find out how do we get them. Yes, it's a challenge. First, I've spoken about circuits. The tribunals that have caseloads from those areas conduct circuits, and usually they're physical circuits. But more importantly, even if a tribunal had one case in Garissa and they are in Nairobi, in terms of making sure a litigant is heard, litigants have, or rather the judiciary has a machinery where we have courts assisting litigants to log in at help kiosks inside the judiciary buildings to make sure that they have online connection. So a litigant is encouraged to approach or go to the nearest court station and actually get assisted there. And so the access to justice pillar is to ensure, yes, there's proximity to a physical building, which is a court, which has facilities that can enable a person to access justice, but also the continuing discussion on Huduma centers, which are around the country. It's one of the doorways or one of the methods that the judiciary is keen to utilize to allow litigants where government services have reached. Litigants from those areas can actually complain through, or get access to justice services using the available machinery on the ground. But this is an area that we'll have to keep exploring based on justice needs assessment in different areas. But the pillar on access to justice emphasizes both on functional access in terms of courtrooms, but also procedural access in terms of rules and what have you. And so in terms of structural access, you will have litigants being assisted at the places where government services are, and those are the Huduma centers. And Huduma centers are, I think, almost in the entire country, which is why the leadership of the judiciary is exploring that mechanism to ensure that if you're completely unable to reach a court somewhere, or a tribunal, then you're assisted in that way. But also it's important to remember that even proximity to courts, or physically or otherwise, is dependent on the resourcing that the judiciary gets. So until the judiciary is resourced to a magnitude where and the vision is to have a court in every county, and a magistrate's court in every sub-county, so that people have access to where you have your market centers and what have you. So the resourcing requirement, or the resourcing needs, are the ones that we need to continuously look at and champion to ensure that this is possible. So it's a conversation that one cannot say there's a one-fits-all solution. It's something that the entire justice chain and the entire justice sector needs to agree on, because you can resource one institution, and if you under-resource the judiciary or any other institution in the justice sector, then the whole chain suffers. So it's important that the resourcing is done based on the needs assessment that are required. So that's what I would say about that.
Yes, so thank you for responding to that. And I hope that I'm now audible enough. I've changed to a different gadget. So back to you, Dr. Orina. Before we take any questions on the floor, I'd like to hear on maybe, okay, I know you touched on creating some jurisprudence and you've made some decisions in terms of the awards, awarding some cases, and then also ensuring that any affected parties are granted the supporting valuation documents so as to, give an indication in terms of how a certain compensation was arrived at. But then I'd love to hear on any maybe landmark decisions you've made or any big decisions you've had out of the 30, maybe the most challenging, so that, we can get to appreciate the impact of the tribunal.
Okay, thank you. Let me start by saying every case that comes to us is the biggest we see on that day, but of course there are cases that require a bit of more assistance in terms of the technical expertise that we need, or the kind of decision that we have to make. And I will single out one particular one. This is a case that came out of one of the acquisitions in regard to the SGR project. Essentially, a case where parties are claiming that the size of land that a big government project has occupied is almost double the size of land that was gazetted for acquisition and what was compensated for. So then here is a situation where the parties are saying that more was taken from us than what was compensated for. But a situation where there are no survey reports. Of course, there's kind of communication where even the acquiring entity admits that, well, this is what we took. So even though that what was gazetted is a certain amount, we took more, but that is what we paid for. So it's a question of what was paid for or what was acquired. And the entity doing the acquisition itself says, no, we only acquired what we gazetted. So they're kind of even the respondents are taking different positions. The complainant is also taking a different position. So despite making orders that the respondents supply us with the proper survey reports to ascertain their claims, they still did not avail those reports before the tribunal. And this is also a challenge, I think a general challenge in terms of us meeting the strict timelines that we have, where we have parties before us who do not comply. And yet, I think one of the other things that probably Madam Asuga would have touched on is the question of what do you do with failure to comply with orders? Do tribunals have powers to punish for contempt? And it's a debate that has been ongoing, and this is also an ongoing debate in the draft bill, the tribunals bill, which is before Parliament. Because if you are creating courts of law or tribunals and you do not give them powers to ensure that their orders and their decisions are complied with, then you are creating toothless dogs that will only bark, but then it becomes pretty difficult for certain things to be done. So in a situation like this, then where, the parties have not availed anything to us, despite giving, requiring them to supply these documents and giving them a chance to conduct certain steps. We then have to, as in that case, we had to make a decision that a matter cannot be before us forever, where we are sending parties back to comply and they're failing to comply, where we then we reasoned out that there are sufficient reasons have been shown to us that this acquisition did not comply with the whole procedure that is required because of the questions that have been asked around it, because of the different positions that have been taken. And as final orders, then we ordered that the respondents actually do conduct afresh certain procedures, which after conducting of those procedures, then they would have to reissue a new award, whether or not they ascertain that their positions were right or wrong. Then after that, then it's left to the party who came before us, the complainant, to ensure that there's compliance through other procedures of execution of judgments. And I think that, of course, that is another area that parties have to go through, and it has its own challenges. But what I can say about the cases that come to us every day, there's a new case coming to us. The kind of issues that are coming, that are being brought by advocates, because all the parties before us have been represented, and sometimes you have to understand the need for lawyers to be involved in such complex issues because of the complexity of the matters that are involved, of the questions that are involved. So there is on an everyday basis, we get to be confronted with very complicated questions that then we have to, as a tribunal, sit down and give guidance on the same. We've also, I forgot to mention, we've also got references, files transferred from the Environment and Land Court, because some of these matters that were filed before the tribunal came into existence were filed before the Environment and Land Court, and the Environment and Land Court has transferred a number of the files to us, which we have determined, and others are ongoing. And I think it's important to see how this jurisprudence develops. So far, we have only had, I think, one appeal from our decision that is on our jurisdiction, which has gone to the Environment and Land Court, which is also good, so that then, with finality, the appellate mechanism can clarify the question of our jurisdiction, especially the biggest contestation that has arisen in regard to our jurisdiction, and probably that is also one of our big decisions, is in regard to jurisdiction on questions of way leaves, whether it's by entities like a truck or etc., and whether these competing overlapping jurisdictions between the tribunal and on the one hand, and the Energy and Petroleum Regulatory Authority on the other hand, or even the Energy Tribunal on the other hand. So sometimes there are competing jurisdictions due to or overlapping jurisdictions due to how certain laws were drafted. But for us, we have determined that indeed this is an area where we have jurisdiction. And something else I should add, so that because now that we're all advocates here, potential areas of practice. I haven't seen a lot of practice around easements, or a lot of questions about easements, because we see all over everywhere complaints about people's houses being flooded because somebody blocked a waterway that has been in existence for the last more than 50 years, and now someone's house gets completely flooded. That is a question of easement. We have seen questions of the right to light. So I think it's upon us as lawyers to also be creative and exploit, the legal provisions, the legal procedures that are available to ensure that your clients are also get to benefit from some of these rights that are there in the law. For instance, another aspect would be if you want to take building material to your land, but your land is completely blocked off because of developments around it. You actually have a right to pass through your neighbor's land, if you're able to do that, to take building material to your property. But if your neighbor says no, what do? The jurisdiction is with the Land Acquisition Tribunal. That is a right to easement. Easement is a non-possessory right which can be derived from a property, and that is one of cases where we can actually issue orders for easements. And those are not complicated cases. Those are cases you can come before the tribunal, and within a few weeks, not even a month, you have your order to ensure that your client, instead of trying to go to the magistrate's court, go to the ELC, and then you will end up again being referred back to the tribunal. So I think there is, to sum this that discussion on jurisprudence, it is a great potential and for practice areas for advocates, especially in this area about these kinds of rights over property that the tribunal has jurisdiction over.
Okay, so thank you so much for that. So I'd like to open the floor. If anyone has a question, let's maybe raise our hands up. Then we can be given the chance to ask the questions. Raise your hand up.
There's a question in the chat. Maybe you could start with that.
Okay, great. Okay, since I changed my gadget, maybe it might have interfered. So Dr. you kindly just proceed, read it out, and then respond.
Okay, this is a question from Saima. Question 1, how does the Land Acquisition Tribunal deal with the acquisition and compensation of community land, especially unregistered community land, where it is customarily known that a certain community owns the particular piece of land, but not registered as such? And 2, are there any challenges faced when enforcing the tribunal's judgments? How has the tribunal dealt with such? I'll start with the first question. The first question, community land. So unregistered community land under the Community Land Act is held in trust by the county. So if an acquisition was to happen on community land, that acquisition then would turn that community land to public land. But then if an acquisition happens on a community land which is registered, then the community will be compensated. However, in a situation where a community land is not registered, Section 6, subsection 2 of the Community Land Act states that the county government shall hold in trust for a community monies payable as compensation for compulsory acquisition. So if community land is compulsorily acquired and that community is not registered, then such monies shall be held by the county in trust. And upon registration, then the county government shall promptly release the monies payable to that community. And these monies, of course, are put in a special interest earning account. So all this is the process at the level of compulsory acquisition. However, then there could be instances, for instance, where a community has been registered, but the monies that were payable were paid to the county to hold in trust are not paid to this community. So since this is a question that touches on compulsory acquisition of land, then the community can file an application before the tribunal for determination whether their rights are being violated by the failure to remit any money that was paid to account to hold in trust. Of course, when you look at that Community Land Act, there are a lot of elaborate provisions in terms of how communities can be registered, communities that own community land, and even the creation of the community land registrar under Section 9 of the said act, that is a Community Lands Act. So if along the way any of those processes for violates the rights of any communities to compensation from compulsory acquisition of their land, then such a community can file an application before the Land Acquisition Tribunal. So that's the first question. The second question, are there any challenges faced when enforcing the tribunal's judgment? I don't know so far whether the parties have experienced any challenges, because the tribunal itself, under the law, has a deputy registrar. So the orders of the tribunal, decrees are issued through the tribunal itself, and then the normal business of enforcement of the decrees or judgments can take place in case, because most of these and these suits are against the National Land Commission and other government agencies. Then the parties who are the decree holders can take other measures to ensure that they enforce the decrees against the agencies given. For instance, they can even go for contempt of court or seek against garnishee orders for payment of these monies if they're being held in accounts. So those are some of the ways that they can do. But I do not know whether they faced any challenges so far, because for us, our work stops at issuing the judgment and processing the decree. So enforcement then is upon the parties going forward. I think the next question on the Rent Restriction Tribunal, that I might have to leave to.
Yeah, indeed.
I think the registrar has answered that one. Yeah.
Yeah, indeed. For Benjamin, we've seen your question. We've seen your question on how do you execute rent restriction tribunals directly or must be adopted by the court prior to execution. Maybe Honorable Anne, you can kindly answer in, yeah, she's already answered. So let us know if you're satisfied with the answer, Mr. Benjamin, and thank you for your question. So are there any other questions? Any other questions? If anyone wishes to even just ask, we can still give you that opportunity to ask your question. Okay, we can see you, Patroba, very impressive and very clear. Okay, thank you for that. Okay, so if there are no further questions, I believe we've covered majority of the key items when it comes to the Know Your Tribunal series. We've gotten to learn about the Land Acquisition Tribunal, and maybe before we have the parting shots from our panelists, Dr. Orina, perhaps you can advise, because we know we've had a massive growth when it comes to the numbers of advocates. So are there any opportunities that lie in the tribunal, that the young advocates can look forward to?
Well, all advocates and young, and actually we've had impressively a number of young advocates coming to practice before the tribunal, which is very impressive. So they are welcome to practice before the tribunal, and hopefully in the future they will be able to, through our registrar, convince the JSC that they need to give us researchers as well, because you can imagine that we are all part-time, and sometimes we get to get a very heavy workload. So maybe in the future, the Judicial Service Commission might consider that they can send, at least attach 1 or 2 researchers with the tribunal, which would be a very welcome move, at least to assist the tribunal and also to help develop capacity for young advocates who have an interest in this area of law. But in the meantime, I would say that there are very interesting issues being practiced before the tribunal. Any of the young advocates have an interest, feel free to log in anytime. The course lists are always available online, so get to learn and also get to learn what the tribunal does, and that is the way you'll be able to also bring your clients before the tribunal and file matters before the tribunal. And if you need any assistance, our secretariat is always ready and willing to assist for parties who wish to come and to file matters before us.
Okay, so thank you so much for that. I cannot see any further questions on the chat. I can only see comments in terms of the great presentation and the recognition. So at this point, I'd love to invite our panelists to give their parting shots in terms of the Know Your Tribunal series, having considered the Land Acquisition Tribunal today. So we can start with Honorable Anne Asuga, and then we come to Daktari, and thereafter I'll just give some thank remarks, and we can close the session.
Yeah, thank you. Thank you so much, Josephine. I think it's been a very insightful session, and thanks for your participation. Thanks for the participation of everyone who has joined us. Just to mention that, yes, there are very many opportunities for young lawyers to practice in tribunals, because the sectors for which the tribunals are established are on a daily basis. Business premises, with all business premises that are controlled tenancies, with rent issues, cases for resolution by the tribunal. Rent restriction has very many opportunities as well. Sports, energy, and petroleum. And the education sector has the biggest potential, especially with the current or the recent establishment and operationalization of the National Examination Appeals Tribunal, which we call NEET, because it deals with exam malpractices and decisions of NEC. So then you find that in the recent finished exams, there were a lot of disparities, and so the ministry operationalized or asked us to operationalize that tribunal. Now it's working. So with parents and students dissatisfied with NEC processes or the decisions of NEC, they can come there, and lawyers will be required, or they will require lawyers to come and state their case. There are opportunities in HIV and AIDS tribunal, also in the education sector. We see, many of the cases coming from students discriminated in that regard. Opportunities with public-private partnership and petition committee, especially now because county assemblies can form public-private partnerships with enactment of the PPP Act 2021. You have environment issues with all the buildings coming up. There's a lot of litigation going around at the National Environment Tribunal, and there are many opportunities for lawyers in that area. So the opportunities abound. It's only that perhaps we are not aware of where the tribunals are, and that's why we are having this forum. And if you go to the creative sector, with the Copyright Tribunal now in place and established, you also have issues of infringement, and that would come in handy. So we shall continue to sensitize and to spread the information. And for you to have a full overview of the tribunals, their mandate and jurisdiction, kindly log into our social media pages. At Twitter, it is at ORT with capital O and capital S, ORT Secretariat. Capital O, capital S. At Instagram, it's ORT_secretariat. So you will find us and we post, you can follow us to find out the news about tribunals. We post our cause lists there. We post our news there, swearing-ins and which tribunals are operational. And if you need any information, you can actually get it from there. So I want to thank you very much and wish you all the best. And we hope to see you soon. Asanteni sana. Thank you.
Okay, thank you for that, Dr. Nabil.
Thank you very much. I also join Madam Masuga to thank you for inviting us and also for offering this platform at least to familiarize the membership about tribunals. And I would like to encourage members also one more time that if you want to pursue practice that is result oriented, then that is a practice before tribunals. I know the courts have their own challenges. It's not that they want to be deliberately slow, but tribunals are one way of ensuring that indeed you can get quick results on all these technical areas. So all the tribunals that have been spelled out by the registrar are operational, and if you want to practice in a court that does not adjourn unnecessarily, that sticks to strict timelines as provided for in the law, and then these are the places to practice. Indeed, tribunals are a part of the judiciary that is holding strongly the pillar for access to justice. So we strongly encourage you that explore opportunities for practice before the tribunals. Thank you very much, and thank you all for attending and listening in and for your questions.
Okay, so thank you so much. So I'd like to also conclude this webinar by thanking our panelists. Indeed, it has been an eye-opening session where we've gotten to learn so much about the Land Acquisition Tribunal. We've gotten to have a feel in terms of the matters that are presently filed at the LAA. We've gotten to understand the mandates. We've gotten to see the interlink between the Office of the Registrar with regards to the LAA as well as the other tribunals. So we have gained a lot of knowledge. So allow me to thank our panelists. We thank you, Honorable Anna Suga, for just ensuring that you can give us part of your time despite your busy schedule. So we really appreciate you. We also appreciate you, Daktari, for your time and for the wonderful presentation that you've made. The other category of people I'd like to thank is all of you advocates who have been patient enough up to this juncture. So thank you so much for your participation. And lastly, I would wish to also thank the LSK Nairobi branch for organizing this particular series to ensure that we are sensitized and we are well aware of the different types of tribunals and as well as their functions. So I'd also just like to take note of the good wishes that I've seen on the chat. I've seen a number of you wishing me well in my bid for the elections for the position of the vice chair. So maybe you can also just allow me to seek your support, because I'm seeking a promotion on the position of vice chair. So if we could only also consider that and kindly vote for me so that we can continue engaging and continue having wonderful sessions like these and many more that will benefit all of us. So at this juncture, I believe we've gotten to learn and we can close this session. So thank you all of you, and look out for the next Know Your Tribunal series. Have a good afternoon. Kwaherini.
Thank you very much.
Thank you.
Right. People